Before we begin, I should perhaps explain that, as you can see, there are only four of us sitting in court this morning. Lord Kitchen is unwell and unable to sit with us this morning, but he remains a member of the court hearing this and deciding this appeal, and he will have access to the transcript and also to the live stream of this hearing as it takes place. And with the agreement of the parties, we are proceeding on that basis. Mr. Howard.
My Lord, we're very sorry to hear that Lord Kitchen is indisposed, and we wish him a speedy recovery.
Thank you very much.
My Lords, if I can just complete some remarks on the capacity point, and then I shall move on to authority. Your Lordships, I think, have my essential points on capacity. The concluding remarks I made yesterday evening concerned Ukraine's argument that in failing to apply a state's internal law, the English courts were failing to afford Ukraine sufficient comity, and in our submission, that is misunderstanding what comity means in this context. Comity is applicable where one is looking at a foreign corporation, because the English courts are respecting the sovereign power of the foreign state to set laws within its own territory and determine the powers of entities created by and under their law. Whereas, as I've explained and the Court of Appeal explained, the recognition of a foreign state is rather different. And that, in fact, leads on to emphasizing that there are two, one needs to be careful about the use of the term recognition, and Ukraine, in its submissions, confuses the two. There's recognition of a foreign state, which is an act of the executive. Then there is recognition by the English court as a matter of procedure, pursuant to which entities created by other legal systems are treated as being able to sue and be sued. And so although it's the same word, recognition, it's being used in two completely different contexts.
Sometimes the word cognizance is used.
Yes.
Where the court takes cognizance of the consequences of the executive act of recognition.
Yes. But when we talk about recognition of a foreign corporation, that is something we do under our rules of as part of the lex forum. That's simply recognizing that a foreign entity has been created elsewhere. And so I think we don't need to turn it up. You referred to the bumper case. You'll remember that's the case about the temple and whether the temple was a juristic person. Now, as a matter of English law, one might have some difficulty understanding that sort of concept. But the temple was a juristic person under the law of Tamil Nadu. So the English court recognized that Tamil Nadu had created that legal person, and so the English court then recognized it as a person entitled to sue for the recovery of the statue or idol that was in dispute in that case. The Haggersund commune case, on which Mr. Thankey spent a lot of time, in my submission is of no assistance at all. That's, we don't need to turn it up, but it's in volume 1 of the authorities at tab 4. The reason it's of no assistance, what one was dealing with was a body that was called a commune, which was established under the law of Norway, and it was common ground that the capacity of the commune had to be determined by that law. You see that at paragraphs 7 and 16 of the Court of Appeal's judgment. So it was common ground that Dicey Rule 175 applied, and that led you to Norwegian law. You see that at paragraphs 27 and 30. But the issue in the case was whether those laws were laws of capacity, which laws were capacity laws and which were not. And that was actually the debate that was taking place in that case. So the case, with respect, does not offer much assistance in determining our question, which is what system of law is relevant to determining capacity in the first place. So My Lords, subject to any issues that your Lordships would like me to address, I'm going to move on to authority. Now, the Court of Appeal observed that the issuance of the notes in this case had all the appearance of a valid act by Ukraine. They said that at paragraph 23. Now, that was obviously correct, indeed not in dispute, but it is important for setting the context for the following aspects of the debate. Firstly, was there a representation by Ukraine that clothed the Minister of Finance with apparent authority to issue the notes and to provide representations and warranties that they were in accordance with the laws of Ukraine? Secondly, would a reasonable person in the trustee's position in this context have been put on inquiry as to the minister's lack of actual authority, or would a reasonable person have proceeded with, in accordance with, and to rely on the apparent authority? Thirdly, insofar as it is really a live issue, did the trustee rely on the apparent authority? And fourthly, did Ukraine ratify? And I'll come on to ratification separately. Now, just in relation to this context, and I'm sure your Lordships have these points in mind, I would just highlight some particular features. The first is, it was in fact at Ukraine's suggestion that the transaction took the form of a standard international bond issue. That's confirmed by Galina Pakhachuk, who is the head of the Debt Policy Department. Her evidence is in, we don't need to turn it up, but it's in Appendix Part 2, Volume 1, at MS 9055, paragraph 63. And the essential point was they were preparing for a capital markets bond issue, and they had been doing so throughout 2013. So, as it were, the paperwork for that was ready to go and could be utilised for this purpose. The second point is that the funding was achieved by the notes was as a result of a high-level agreement between the leaders of the two countries, namely the presidents of Ukraine and the Russian Federation, and that was publicly announced on the 17th of December 2013 by the presidents, and it's referred to in Ukraine's defence at paragraph 33. The third point, and we're going to come back to look at this in a bit more detail, on the 18th of December 2013, the Cabinet of Ministers, or CMU, issued a decree in which it stated that the issuance was approved and authorised the minister to carry out the issuance of the notes. I'll come back to that in a moment to look at it in more detail, but you should note the Cabinet of Ministers, unsurprisingly, includes the Prime Minister, but it is also the highest body in Ukraine. Fourth, on the 19th of December, Ukraine's parliament, the Verkhovna Rada, passed a law, which I think you were referred to yesterday by my friend, increasing the outstanding debt limits in the budget. Now, obviously, the position of the Parliament, leave aside Professor Butler's views, but Parliament's view was that this was sufficient to comply with any requirements of Ukrainian law. And that's indeed what the chairman of the Parliament's Budget Committee said, and that's referred to in Mr. Mason Jebb's evidence in Appendix Part 2, Volume 1, MS 8974, paragraph 54. The fifth point is the prospectus. You've, of course, been shown one or two pages, but the prospectus, as you know from relation to these sort of these sort of issues, is a lengthy document. The point, and it's in Appendix Part 2, Volume 3, at page 9745. It might just be worth briefly looking at that.
Can you give me that again?
Yes, my lord. It's Appendix 2, Volume 3, and the page number is MS 9745. And you can see this is a fairly mammoth document. It's some 203 pages, I think. It goes through to 9954, or the last page might be 9953. And you can see on 9746, I mean, there's nothing surprising or controversial. You can see that it bears the Ukrainian coat of arms and is a formal document which is intended to be issued on behalf of Ukraine. And you can see on that it was Ukraine was represented by the Minister of Finance acting on the instructions of the Cabinet of Ministers, and that's the way in which these things are done. It's that formal description. And it is also said, which is the case, if you go to 9952, which is authorization, that the issue...
Sorry, the page again?
I'm sorry, my lord, 9952.
Thank you.
The issue of the notes under authorization is authorized by the instruction of the Cabinet Ministers of Ukraine by a 2013 decree and the resolution that we'll come back to dated the 18th of December 2013. Just going back to 9747, the 9747, these are all standard features, as I'm sure everybody knows, of these type of prospectuses. The top of 9747, you can see that the issuer accepts responsibility for the information contained in the prospectus, and also that they've made all reasonable inquiries and have taken all reasonable care, and it's in accordance with the facts and does not omit anything likely to affect the import of such information. Now, one of the points that you should understand, which I think got rather lost yesterday, you'll know that Ukraine's case is that there is a limit on external borrowing, which is to be found in Appendix 2 of the 2013 budget law. There is not a single reference to Appendix 2 in this document. There is not a single reference to an external borrowing limit. And of course, Ukraine's approach to the prospectus in the way it was submitted yesterday is a totally artificial one. The recipient of the prospectus doesn't look at it and then seek to investigate, well, for instance, is in fact this properly authorized? Any reasonable person would take that at face value. It's also the case that, as it says at 9746, that the prospectus, this is in the penultimate paragraph, has been approved by the Central Bank of Ireland, which is the competent authority under the directive, and it only approves the prospectus as meeting the requirements imposed under Irish and EU law. Now, that directive requires that it contains, a prospectus contains all information relevant to potential investors. That's Article 5 of the directive. There's nothing, of course, in this prospectus to suggest that the notes were unauthorised or unlawful. Of course, the converse is the case. I mean, if you put forward a prospectus where you said these may be unauthorised or unlawful, you're not likely to get many takers. The whole purpose of it is that we are acting in accordance with the law.
Remind me how Ireland come into it. They are the authorised under the EU.
Because it's listed on the Irish Stock Exchange, and so they are the, as it were, the central authority that has the responsibility for regulating it. So you have this, they're traded, these sort of bonds, Euro bonds, are traded in London, but the Irish Central Bank is the...
But that's under an EU directive.
Yes. Yeah, it's because you choose to list in Dublin. I don't know why Dublin's a more attractive place than London for the listing. I'm afraid I can't help you on that. And that's actually the sixth point, that the notes were listed on the Irish Stock Exchange, and that requires that securities must be duly authorised and comply with all applicable laws and have any necessary statutory or other consents. Now, the seventh point, is that in the trust deed and various other documents, there were warranties, which again we should probably just look at. So if we put away Appendix 2, Volume 3, and take Appendix 2, Volume 2, at page... Sorry, I've given you the wrong reference. It's Core Volume 2. It's at 8869 is the trust deed, and the relevant warranty...
Sorry,
It's the core, my lord, core which has appendix. Core volume 2.
Page.
The page I wanted to take you to is page 8879, which is where clause 2.5 of the trust deed is where the issuer represents and warrants to the trustee. And you'll see that what is warranted at 2.5.1, the issuance and the execution and delivery of this trust deed and the agency agreements and the performance by the issuer of its obligations will not cause any violation of any law or regulation in or of Ukraine, and will not cause any violation of any agreement to which the issuer is a party. And of course, one of the points that is made is that, well, none of this matters if the minister didn't have actual or ostensible authority. But a point that's important to bear in mind is the CMU in the decree that we will come to has represented that it's all authorised. Now, there's a debate about whether they had the terms of these documents in front of them, and I'll come back to that separately. But whether they did or not, as I think the court said yesterday, these terms are standard terms of this sort of documentation. And so the CMU was fully aware of the fact that that the minister would be saying it was all in accordance with Ukrainian law, and they, of course, were saying by the decree the same thing. We don't need to turn it up, but there are similar representations and warranties in the subscription agreement, which is in Part 2, Volume 3 at MS 9955.
Sorry, 9955. Thank you.
And the importance of all of this is that on the date the notes were actually issued, which was Christmas Eve, the 24th of December, the Minister of Finance certified that these representations and warranties were correct. And there's a certification in Appendix Part 2, Volume 4, at page 10049 and 10051. The eighth point is all of the documents describe Ukraine in the same way, namely Ukraine represented by the Minister of Finance, acting on the instructions of the Cabinet Ministers of Ukraine. And the significance of that is the 10th point, is that on the 31 previous occasions on which Ukraine had issued Eurobonds over the past 20 years, the relevant transactions were entered into on its behalf in exactly the same way, namely by the Minister of Finance on the instructions of the CMU. The relevant, I don't think, the evidence on that was contained in Mr. Mason Jebb at paragraphs 31 and 77, which is in Appendix Part 2, Volume 1, at 8968 and 8981, and in his second statement, which is in the same volume, at paragraphs 26 to 28, 55 to 56, at pages 9008 to 9 and 9015 to 16. The 10th point is that the trustee also received specific confirmation from the CMU in the form of a certified copy of Decree 904, and that's at Appendix Part 2, Volume 4, page 10041. The 11th point is the legal opinion from Lavironovich and Partners, which you were shown yesterday. But it is perhaps worth just turning that up quickly at this stage. That's in Appendix Part 2, Volume 4. At page 10021. And this, the way in which these legal opinions are done, and it was done in this case, this was a legal opinion which was obtained by Ukraine and which they then provided to VTB, the lead manager, and Lord Debenture, the trustee. And you will see at pages 10022 to 3, there are various assumptions made. What you should note is that, so they don't provide, obviously, an opinion as to the validity of the assumptions, but the only assumption that they made relating to the matters to do with the budget is, you'll find at paragraph 2.9. So there's no assumption in this, nothing said. They don't make an assumption about Appendix 2, because they don't refer to it, because they plainly can't have considered, nobody drew it to their attention, that contained any relevant limit. And the limit that's being referred to in Article 5, it's common ground, there's no question of a breach of that. And so they then go on to give an opinion at page 10024 that the issuer, at 3.1, is duly authorised to execute the finance documents, and secondly, the issuer has the legal capacity and authority to enter into and perform its obligations. And you should note that, so that is, was unequivocal, and if you go back to insofar as there are assumptions, there's the assumption in 2.9, but none of that matters. The other assumption was in 2.6, which related to Resolution 904, which is the decree, and the only assumption they were making about that is that nothing had come to their attention that resolution would indicate that resolution was essentially, they're saying that the internal procedures hadn't been followed. In other words, they were treating otherwise the resolution as perfectly valid. You can put that away, and the 12th point I would draw attention to in relation to these contextual points, it is common ground, certainly not disputed, that the Minister of Finance and the CMU had been validly appointed. So this isn't a case where somebody's saying these were people who didn't actually occupy these offices. Now, there was no contemporaneous suggestion from any Ukrainian state organ or actor, or indeed anyone else, that the Minister of Finance or the CMU didn't have authority to do what they did. To the contrary, each of the President, the Prime Minister, the CMU, the Parliament, and the Ministry of Finance behaved in a way that suggested that the notes were authorised and would be binding. They either expressly took steps to say so, and that's at least the Prime Minister and the CMU, or at a minimum stood by and permitted the Minister of Finance to issue the notes. The 13th point is after the notes were issued, the position was exactly the same. And it's important to note that, as you know from the matters that we've been discussing relating to the duress defence, the high-level members of the government who had been there at the end of 2013, the ones who are supposed to have been acting under duress, in fact fled to Russia. So a new government came in at that stage. And the new government at that stage, in February 2014, first sought to issue further Eurobonds that were going to be fungible with the notes. But then secondly, so that this is the new government, in September 2014, and of course, after there have been...
Sorry, say which year?
September 2014.
Oh, yes.
After the various events in Crimea, the Ministry of Finance denied that, and this was following an investigation by the Security Service, that the notes had been entered into without authority. The third point is, throughout 2014 and 15, Ukraine properly paid some $233 million by way of interest. And the fourth point is that what Ukraine sought to do during 2015 was enter into a general restructuring of its debts. In other words, the familiar thing of inviting creditors to accept a haircut. And Russia, these notes, of which the Russian Federation was the holder, were included in that program. Essentially, Ukraine has taken umbrage at the fact that the Russian Federation wasn't prepared to take a haircut, but the fact that they were asking it to do so was all premised on the basis that these notes were valid. So it's against that background that one comes to December 2015, when they, for the first time, sought to suggest that the notes were not binding. But the most important thing for your purposes is the suggestion that in 2013, when one looks at all of these events, that the trustees should have been on notice, is, we would respect, somewhat ridiculous. Now, Ukraine has put in expert evidence from Professor Butler, based on which it is alleged that, in fact, as a matter of Ukrainian law, the minister exceeded his authority as to external loan transactions, because what he's saying is, firstly, the value of the notes, when aggregated with existing borrowing, would exceed the maximum amount of external borrowing that Ukraine, under its budget law, could undertake that year. And he says that, secondly, the consequence of that, therefore, is that the issue of the notes was a breach of the budget law and of authority. Now, as you've seen, and it is fair to say, this point that Professor Butler makes escaped every single organ of state. The President, the Parliament, the Prime Minister, the CMU, the Finance Minister, and indeed the Finance Ministry, as well as the lawyers whom Ukraine instructed and whose opinion was provided to the trustee. Now, it is not unfair to say that Professor Butler, who appeared in 2016, appears out on a limb. Now, be that as it may, it's a summary judgment application, and so we've proceeded on the basis that his opinion is arguable. But the simple point we make is that whatever the limits per Professor Butler on the minister's actual authority, Ukraine is bound by and unable to deny his apparent or ostensible authority to issue the notes and do all the other things associated therewith that we have just seen. And there are two reasons for that. The first is Ukraine's representations, and those representations arise firstly by Ukraine appointing him and its course of conduct holding him out as authorized to issue Eurobonds. And secondly, the CMU, on behalf of Ukraine specifically, representing and holding him out as authorized so to act in relation to these very notes. And then the second point is ratification. So I turn to the general principles of law that arise here. Now,
We're assuming for these purposes that you've got home on the capacity argument.
yes.
Yeah. Because obviously, if none of these people had capacity, then...
If Ukraine as a state doesn't have capacity, then cadet question, we don't get to this point. And that's the vice of the capacity point, that it is seeking to, the effect of it is that it allows Ukraine to walk away from a transaction. And just while answering that point, it in fact displays, Mr. Thankey's submissions had an element of confusion, because you remember when I think he referred to the Freeman and Lockyer test, and one of the fourth point says, well, you can't have ostensible authority if what the agent is purporting to do is beyond the capacity of the principal. But and he says, the minister can't act beyond the capacity as a matter of Ukrainian law. But that's confusing different things. If we are right on capacity, that Ukraine as a state had the capacity, then you can't, when you're looking at ostensible authority, then say, oh no, it didn't have capacity, which is what Mr. Thankey's submissions were doing. Can I go back?
Which is the organ of state of Ukraine? Assuming you're right on capacity,
yes.
Which is the organ of state that is in a position to confer by representation a sensible authority?
There are two ways in which ostensible authority arises. When you say which organ of state, the first is that the state appointed the Minister of Finance. That's the first thing we mustn't lose sight of. It's like appointing the managing director. And the second is the state appointed the cabinet ministers, the CMU. So those are both entities by the appointment who are held out. Then there is a course of dealing where Ukraine permits the Minister of Finance to act in a certain way. And then we have the statements by the CMU.
Thank you.
Now, it's common ground that the existence of ostensible authority is to be determined by English law as the law governing the contract. Now, so one then needs to work out what one means by ostensible authority, and again, this is not particularly complicated. That's the authority as it appears to others. And in the Ocean Frost, Lord Justice Robert Gough in the Court of Appeal, perhaps we could Just turn that up. It's volume 5 of the authority. At tab 35, which is MS 1886, and 1895, the paragraph, the third paragraph down that begins, "I for my part." The second sentence, he says, "My starting point is, of course, the locus classicus on the subject of ostensible authority, the judgment of Lord Justice Diplock and Freeman and Lockyer. I hope I may be forgiven if I don't quote in extenso from the very well-known judgment. It appears from that judgment that ostensible authority is created by a representation by the principal to the third party that the agent has the relevant authority, and that the representation, when acted upon by the third party, operates as an estoppel, precluding the principal from asserting he's not bound. The representation which creates ostensible authority may take a variety of forms, but the most common is a representation by conduct, by permitting the agent to act in some way in the conduct of the principal's business with other persons, and thereby representing the agent has the authority which an agent so acting in the conduct of his principal's business usually has." And that's not really saying anything that's rocket science. Now, in the East Asia PT Satria case, which we'll come to in a moment, we don't need to turn it up yet, the board described usual authority as authority to enter into contracts of a particular kind. In our submission, that is the question that one is asking: has there been a holding out that this person has authority to enter into transactions of a particular kind? It is also worth just noting that in this area, what English law is seeking to do is to respect the reasonable expectations of honest commercial operators. And that was a point that Lord Justice Steyn made in the first energy case. I don't think we need to turn it up, but it's at Authorities, Volume 9, tab 72, page 3599, and he makes that point at 196. And the perspective, as the board explained in the Satria case, is the perspective of the reasonable person. And questions of apparent authority, as we would respectfully suggest, should be assessed through that lens. So in our submission, before coming to look at the way the Court of Appeal dealt with it, we suggest that just applying standard principles, Ukraine has appointed the Minister of Finance and permitted him to act on its behalf, and represented that he had the authority to enter into transactions within the usual scope of his office. Mr. Justice Blair said, "It doesn't necessarily follow that every Minister of Finance anywhere in the world has authority to issue bonds." Now, let's assume that's right for present purposes. It's actually not the issue. The issue is whether, in this case, issuing Eurobonds was within the usual scope of authority of the holder of this office, this Minister of Finance. And we submit that it was. Now, can I then ask you to look at the representation by the Cabinet of Ministers? And that is in Decree 904, which is in Appendix Part 2, Volume 3, at 9741. this document, you can see, the reason I say the Prime Minister, you can see he, as you'd expect, leads up the CMU, and he's the person who signs it. And it's a two-page document, and so we see on the front page, it's 18th of December, it's a CMU resolution on carrying out external state borrowings in 2013 for the purpose of fulfillment of the law of Ukraine on 2013 state budget of Ukraine. The Cabinet of Ministers resolves. But just stopping there for a moment, self-evidently, the CMU is saying that this is in accordance with the 2013 state budget law, because it's for the purpose of fulfilling that law. Then it resolves, firstly, to carry out external state borrowings by way of issue of the notes, to approve the terms and conditions of the notes of 2013 attached hereto, for the Ministry of Finance to carry out issue of the notes pursuant to the terms and conditions approved hereby, during the preparation of the draft to envisage funds for the draft for the state budget of Ukraine for the respective year, to envisage funds for the repayment and service of the notes. But just stopping there for a moment, one would have thought that is clear and unequivocal, and amongst other things contains a representation the borrowing is in accordance with Ukrainian law, a representation that the minister has authority to do this. Now, on the reverse of it is a document, or is the bit that deals with terms and conditions, and you can see the notes shall be issued in the aggregate principal amount of 3 million. 3 billion, 3,000 million. The denomination of one note shall constitute $200,000 and so on. Interest is 5% per annum. Interest is payable every year in June and December. Maturity date is the 20th of December. Repayment and financing are financed by funds envisaged by the state budget law for the respective year for the purposes of repayment and servicing the state debt. In other words, this is all in accordance with what the state budget law requires. Terms and conditions of the placement of the notes shall be specified by the prospectus. Now, just stopping there for a moment, we'll come back to this. It's that paragraph which is relied on to say that the CMU has delegated to the minister drawing up the terms and conditions of the notes. Now, that is certainly not something that one would naturally infer from this document in our submission, because what one would, if it is the case, and that's the big if it is the case that the CMU is the body that's required to consider all of the terms, if you understood that, you would assume that the CMU had in front of it the terms, and all it's saying there is it set out the key terms, and then saying the terms and conditions shall be specified by the prospectus. But that's what you would expect. It's just reciting that the prospectus will contain the terms. It does not say anywhere that, and bearing in mind where you are, it's the 18th of December, it doesn't say the terms and conditions haven't been put before us and we're leaving it, we're delegating to the minister the power to do all of this. And we'll see in a moment how this argument has developed to suggest that there was some inappropriate delegation. But
we're just looking at, on the previous page, paragraph 2 approves the terms and conditions of issue of the notes attached here too.
yes,
So that must be referring to the terms and conditions which we have on the reverse, on the next page.
yes.
And in paragraph 3, for the Ministry of Finance to carry out the issue of notes pursuant to terms and conditions approved hereby, presumably that's also referring to the same terms and conditions on the next page.
Well, the answer is, assuming it's referring to the terms and conditions on the next page, what it doesn't tell you is that what is intended to be done is that they don't have in front of them the terms and conditions, which of course are in draft at that stage, because that they're not actually entering into it. It doesn't tell you, it just doesn't tell you anything one way or the other. And the simple point is this. There are two possibilities. One is, which is what Professor Butler says, that only the CMU can determine what are the terms and conditions. Now, if you assume that is the case, then the only natural reading of this is that the CMU has seen the terms and conditions and has approved them. Because why would you infer that the CMU is acting contrary to law? The alternative is that that isn't the law, and then either the CMU has approved it or they've left it to the minister. But the reason we need to spend, I'm spending a little bit of time on this, you'll see in a moment the Court of Appeal has got slightly confused in that it said inconsistent things about this area of the case. But not least because a concession was made about it below, which has been withdrawn in this court. But let me come to that in a moment. The first thing we've got is we see this document, which contains, as well as being, the important point to note, as well as this being a decree, it contains, via that decree, representations and holding out of the minister. And this document is the one that was then provided to the trustee. You saw it referred to, I showed you, in the prospectus, and it is provided to the trustee prior to the agreements being formally issued. And that is referred to in the evidence of Mr. Mason Jebb at Appendix Part 2, Volume 1, at 8977 at paragraph 60 to 62, and at MS 8981 in his second statement, and I think it's still his first statement at paragraph 76. Now, Mr. Justice Blair held that by this document, the cabinet minister or ministers of Ukraine had held out on behalf of Ukraine the Minister of Finance as having authority. Now, the Court of Appeal disagreed with that, and in my submission with respect to the Court of Appeal, this is something of a muddle. The basis of the Court of Appeal's judgment was that Article 16.1 of the Budget Code did not authorise the CMU to delegate to the minister the decision as to the terms. And you'll see that if you go to the Court of Appeal's judgment. At paragraph 130, where they say that there can be no question of identifying the usual authority of the CMU in the abstract without regard to its actual authority under Ukrainian law. Article 16.1 of the Budget Code is clear. The issue of external debt requires, first, instructions as to the terms from the CMU, and second, the necessary actions on the part of the Minister of Finance. Under 16.1, the CMU has no authority to delegate to the minister the decision as to the terms of the borrowing, which by virtue of 16.1 is a matter exclusively for the CMU. In these circumstances, the CMU can have no usual authority to clothe the Minister of Finance with an authority which is contrary to the express provisions of the Budget Code. Now, this has a number of problems with it. The first is it entirely misses the point. Decree 904 constituted a representation by the CMU that the Minister of Finance had authority to enter the bonds. The question that the court should have been asking itself is, did the CMU have authority on behalf of Ukraine to make that representation? Now, for present purposes, we are dealing with a question of the apparent authority of the CMU. So the question was it within the apparent authority of the CMU to represent that the Minister of Finance had authority? Now, in our submission, the answer to that question is plainly yes. Now, if we just pause for a moment and ask as a matter of common sense, who would you expect to ask if the Minister of Finance in Ukraine had authority to do what he was doing? I would respectfully suggest that one would go to the highest agency within the system of agencies of executive power, to quote Article 1 of the law on the CMU, which is at Appendix 2, Tab 3, Appendix 2, Volume 3 at page 9679. Also, who would you expect to ask if what the minister was doing was in accordance with the laws of Ukraine? And you should note the oddity in this case of the submission, the extreme position that Ukraine takes. It says no one in Ukraine could make an effective representation that the minister had authority. Because they say whatever anybody said, whatever any law firm that you go to said, doesn't matter. It's ultimately an objective truth, as it were, which is the Professor Butler view. If Professor Butler's view is the one that ultimately prevailed in the Supreme Court in Ukraine, might be disputed all the way up, that then is the only view. It doesn't matter. It's impossible for anyone else to make a representation. Now, in our submission, this actually betrays a basic misunderstanding of the law of apparent authority. And what we're concerned with is an English concept. Was there a holding out as a matter of English law? That's the first question. And a second question, would a reasonable person be put on inquiry? Now, there's an illustration in a governmental sense of this arising in a case called Marabini, which is in the Authorities, Volume 11 at tab 105. I don't think at the moment we actually need to turn it up. But the issue in that case is a decision of Mr. Justice Creswell in the Commercial Court. The issue is whether a Minister of Justice had actual or apparent authority to issue an opinion stating that a Minister of Finance had authority to enter into a guarantee. And the reasoning in the case was that, amongst other things, was that the Minister of Justice would be expected to have authority to issue the relevant opinion letters. You'll see this all set out at paragraphs 125 to 127 of the judgment. Now, in our case, there's no dispute that the CMU, as I've said, was validly appointed by the state of Ukraine in accordance with applicable constitutional requirements. We suggest a reasonable person would expect the CMU to have authority to make representations as to the authority of the Minister of Finance and whether he was acting in accordance with Ukrainian law. And that was precisely what was done. And so the CMU was acting in accordance with its usual authority. And pursuant to that, it held the Minister of Finance out as having authority to enter the notes and to provide the warranties and representations that I've shown. So we say the Minister of Finance, through this route also, had ostensible authority. Now, the Court of Appeal, if we go back to the judgment at 132, I would respectfully say, confused. It says, the person holding out an agent so as to give them ostensible authority must have actual authority to do so on behalf of the principal, or ostensible authority derived from someone with actual authority. Ostensible authority is not otherwise sufficient. If, when stating that the Deputy Minister of Justice of Mongolia had apparent authority to issue opinion letters, Mr. Justice Creswell was meaning to refer to ostensible authority as opposed to implied actual authority, we consider he was wrong. Now, the confusion in the case is this. The Court of Appeal was right to say that the person doing the holding out, in our case and what we've just been looking at, the CMU, must have actual authority or ostensible authority. Secondly, necessarily, apparent or ostensible authority, and the usual authority that flows from that, must be derived from someone with actual authority. Otherwise, it's not ostensible authority at all. What the Court of Appeal has failed to understand, in Marabini, the ostensible authority came from the appointment of the Minister of Justice, the Ministry of Justice. In our case, the CMU's ostensible and usual authority was derived from someone with actual authority, namely the state of Ukraine, because there is no dispute that it was appointed by the state of Ukraine. And so the state of Ukraine clothed the CMU by appointing it with apparent authority to do things within the usual scope of such an entity and to make the representations that it did. And if you look at it from the other side, it is impossible, I would respectfully suggest, to consider that a reasonable person receiving Decree 904 would not take that as confirmation that the Minister of Finance had authority and that that was confirmation from the highest level in Ukraine. Now, if we go back to the Court of Appeal's point about delegation, that was a non-point, firstly, because it doesn't address the representation. What the Court of Appeal appeared to be saying is that the CMU could not make a representation which clothed the Minister of Finance with authority to determine the terms of the notes. Leaving that aside, my first point, which is that it's not addressing the representation, the point is a bad one on its own terms. It's first a bad one because what we're dealing with, what have been called the constitutional principles relating to the passing of Decree 904, of which there were two. One was that there should be an expert opinion before the court, and the other was that the CMU had to approve all the terms of the notes. Now, it was common ground before Mr. Justice Blair and the Court of Appeal. The trustee could not have known of those breaches and did not have notice of them. And that is actually recited itself in the judgment of the Court of Appeal. The references to before Mr. Justice Blair are paragraphs 149 sub 5 and 164 of his judgment. But in the Court of Appeal, if you turn back to paragraph 118, this is the oddity of this. At 118, the court correctly records that as regards the breaches of the constitutional principles, it remains the case that Ukraine does not suggest that Lord Debenture could have known or had notice of those breaches. But when you go to paragraph 130, the Court of Appeal, even though it's not, the Court of Appeal at 118 is reflecting the fact that it was common ground that you couldn't know, that when you come to consider Decree 904, somehow it has become evident. Or they may be making the point, which I'm going to come on to later in a moment, which is that ostensible authority is basically coextensive with actual authority, so that if you don't have actual authority, you can't have ostensible authority, and that's another sort of fundamental error in the court's judgment, which I'm going to come to. But the simple point is, I've shown you the decree, that what was common ground is entirely correct. In any event, it would also not be evident from Article 16.1 that delegating these terms was in any way, if that's what was going on, problematic. Where's Article 16.1? Doesn't matter. Okay. Now, so stopping there, before we consider the other aspect of the Court of Appeal's judgment, in our submission, even though it has to be accepted for present purposes that the Minister of Finance, in fact, he exceeded his authority, through this conduct that I've referred to, we would suggest it's about as plain as case as can be imagined that the Minister was held out as having authority. Now, that then leads one to what is a central point in the Court of Appeal's judgment relating to Article 16.1. And for this purpose, you need to go back to paragraph 92 of the judgment. Which Mr. Thankey drew your attention to. And this is the paragraph where essentially the Court of Appeal seems to be saying that that there's no place for ostensible authority where the agent has express authority with regard to the type of transaction in question. Now, what they appear to be saying is that the minister's function in relation to borrowing is set out in Article 16.1 of the Budget Code, and so there's no room for the concept of ostensible or usual authority in such a situation. Now, in our submission, this betrays a misunderstanding of the law about apparent authority and is contrary to principle. And if it were right, it would actually mean that there was never any scope for the principle of apparent authority in most situations, and certainly the situation where an agent was acting dishonestly, but that dishonesty was not apparent to the third party. Let me illustrate the point. For instance, X appoints Y as his managing agent. X then tells Bank A that he has appointed Y. Y then enters into transactions on behalf of X with Bank A. Now, we just pause for a moment. If I tell somebody, if X tells the bank that Y is his managing agent, and let's say he's given the managing agent general powers of general authority, that authority is always subject to an implied restriction that the agent must act honestly and in the best interests of the principle of X. So on the Court of Appeals approach, you've got actual authority, which is that the agent must act honestly and in my interests. But the ostensible authority, according to the Court of Appeal, is entirely coincident with that, because you know those are the terms, and so the only holding out is that he is my agent so far as he acts honestly and in my best interests. Now, if you then consider a situation where he doesn't act honestly, that's a case where there's no actual authority. The third party says, but you held him out. Well, on the Court of Appeals approach, the answer is, well, I held him out so far as he was acting honestly. And if in fact I've established he wasn't acting honestly, there is no holding out of any relevance. Whereas, of course, the way English law approaches it is what you look for is a holding out to enter into transactions of a particular kind. And in my example, what the law then says is the third party can rely, unless he's on notice, that the agent is acting improperly. And that is how the law, essentially in this area, satisfies the expectations of reasonable commercial parties.
But your example is of an express representation by the principle of the agent's authority. What the Court of Appeal is discussing in paragraph 92 is what they call usual authority, which is an implied representation by the holding of office. And I think what it is saying is, well, if there is a representation to the public in, for example, the company's articles of association, that the authority is limited, the mere possession of that office doesn't give rise to an implied representation that there is a wider authority. What's your objection to that analysis?
Well, my Lord, take an example where what the articles say is the managing director has power to borrow, subject to approval up to the limits in each case agreed by the board. In my submission, what you have to look at, that is going to be a factor, but you have to look at the entire course of conduct to see, in fact, what the holding out is. Simply saying, well, I mean, if you take our case here, simply saying that there is this rather abstruse position in Ukrainian law where arguably what the budget law means, but nobody realized it, that there's some limitation. The question is, well, have you simply held him out as the right person to enter into Eurobonds? And providing you weren't to know that he was in fact exceeding his authority, which we say you weren't, that is sufficient. But the point in our case, this analysis, we say it's wrong, but it also doesn't get round the point by reference to the CMU, because the CMU has made a representation that this is all in accordance with what the budget law requires. And so the question is that's why the CMU's position is, with respect, particularly important. Because if you have a position, let's say, and I'm going to come on to whether that a further flaw, the idea that you are deemed to know all of Ukrainian law.
But that's a different matter altogether. But
it is.
I can see how you can say that it is one thing to say that the mere possession of an office of managing director is not an. I see how the Court of Appeal can say the mere possession of an office of managing director doesn't contain a representation which is contrary to the provisions of the managing director's power in the Articles of Association, if nothing else is said. That seems to me a not particularly objectionable assertion. But you're saying that things were said.
What I'm saying is, and that's actually what has been said in this court, or not this court, in the Privy Council, in the P.T. Satria case, if we could just turn that up, and it's said by reference to an Australian decision, which is essentially the point is you have to look at the entirety of the conduct. The P.T. Satria case is in volume 1 at tab 3, and Lord's Law. Reid and Lord Carnwath will may or may not remember the case. I'm not saying it was a particularly memorable one, but
No, I have a vivid memory of this case, and
yeah, there were certain
Lord
aspects
Kitchen
of it
even more so, I expect.
There were aspects that stand out in the memory,
Yes.
but I won't dwell on those. But at paragraph 64, the board referred to the case of Northside, which had been cited. We have that in the bundles, but if this is the relevant part, it's in the bundles if you want to look at it, volume 13, tab 114. But and the argument in that case, just to put it in context, was about whether what the appellant was trying to do was to spell out an authority the wrong way round. They were trying to rely on the indoor management rule to somehow say that you could say somebody had authority, whereas the point was there wasn't any holding out, so you never got to any such considerations. But at this stage, the board was setting out the principle, and you can see the limitations on the scope of the indoor management rule as described by Mr. Justice Dawson in the Northside case in the following passage, which was cited by approval by Lord Newburger in Akai. The correct view is that the indoor management rule cannot be used to create authority where none otherwise exists. It merely entitles an outsider, in the absence of anything putting him on inquiry, to presume regularity in the internal affairs of a company when confronted by a person apparently acting with the authority of the company. The existence of an article under which authority might be conferred, if it's known to the outsider, is a circumstance to be taken into account in determining whether that person is being held out as possessing that authority. In other words, the indoor management rule only has scope for operation if it can be established independently that the person purporting to represent the company had actual or ostensible authority to enter into the transaction. The rule is dependent on the operation of normal agency principles, and so on. And the point is, and as my Lord Hodge says, that if you're dealing with a case where you have no dealings other than you're relying on what is set out in the articles, then obviously what the Court of Appeals says is right. But if you have other dealings, then you've got to look at the totality of the dealings in order to see what has been held out.
Yes, but what was being said in paragraph 92 by the Court of Appeal was in the context of this rather unsatisfactory concept of usual authority. So one is looking to implicit representation rather than explicit representation.
Yes. Yeah. But in our case, one just sort of stands back from this. You've got, of course, you've got the appointment of the minister, you've got the prior course of conduct, you've got the CMU statements. And it is true that Article 16.1 states that borrowing shall be effected within the limits of the law of the state budget of Ukraine. It's actually worth just turning that up again because it's in Appendix 2, Volume 3. And just so, I think it is probably quite important, you should actually see how this all arises. And we're going to come on to this question of perhaps I can just make a very brief point about it now. There's a suggestion in the Court of Appeals judgment, more than a suggestion, that you're deemed to know the law of Ukraine. Now, that is, with respect to the Court of Appeal, completely wrong in principle. You're not deemed to know the law of the United Kingdom for all purposes. And that was a point which used to be our law, and that was part of the difficulty with claiming a mistake of law in restitution. So, because you deemed to know. Whereas in Kleinwort-Benson, the House of Lords said, and Lord Gough said, that maxim that ignorance of law is no excuse, deemed to know the law, has no application. It's a principle that is relevant in the criminal law when it's not open to a wrongdoer to say, I didn't know about this criminal aspect of the law, but in the civil law that's long been discarded. And still less is it relevant to a foreign law. And so what you actually have here is, and so the premise of a lot of the discussion and the basis of both the Court of Appeal's judgment and my learned friend's submissions are dependent on this assumption. But just so you can see how it all fits together, at page 967 is Article 16.
Sorry, 967.
9675 is Article 16. And if one just reads it, one sees what it says is state borrowings shall be effectuated within the limits determined by the laws on the state budget of Ukraine. Then if you ignore the bits in parentheses, which are talking about giving an exception, in compliance with the maximum volume of state debt at the end of the budget period. Now, that, just reading that, see, it's not for us to, as it were, decide what the position is as a matter of Ukrainian law. But if you say a non-Ukrainian, indeed this is how all the Ukrainians appear to have read it, that is just saying you've got a limit for the maximum volume of state debt at the end of the budget period. And the reason that's important, if you then go at 9715, you there have the law on the state budget. And what you find is that Article 5...
Could you give me the page number?
Yeah, I'm sorry, my lord, it's 9715.
9715.
In this same volume.
Okay.
And what you'll find is that on page 9716 is Article 5 of that law. And so that is, Article 5 is the maximum limit of state debt of so much in the, I can't remember what you call the Ukrainian currency, hryvnia, I'm grateful, at the 31st of December 2013. So if you just flick back to page 9675, you can see that that is what part of what is would appear to be being referred to as a limit for the maximum volume of state debt at the end of the budget period. Article 1, and no one is saying there was any problem with that. Article 1 is then dealing, I won't read it out because it's fairly long, but it starts on page 9715 and goes to 9716. That is dealing with the deficit. So in other words, as you know, we're all familiar with these things. One is the amount of overall debt, and the other is the deficit, i.e. the extent to which your expenditure exceeds your income, a problem that most countries seem to experience. Now, the reason for pointing that out, those are two things that you could... the one in Article 5 is the one that appears to be being referred to in Article 16.1. You might be able to argue that the one in Article 1 is referred to. But what Professor Butler says is that you then have to go to Annex 2, which is on page 9734, And what is in Annex 2, which is the financing of the state budget for 2013, you were shown this, I think, in Professor Butler, but it's useful to see it in the statute. This is said by Professor Butler to create limits. Doesn't say that anywhere, but what he says is line 401200, which is external borrowings. His thesis is that that is a limit on external borrowings. And it's also important to understand that what he's saying is not only is it a limit, but you can't move things around. So, for instance, you can't borrow more externally and less internally. There's a limit, it's an absolute limit. And the new argument is that not only is it an absolute limit, it's a gross limit. So that if you, in month 1, borrow the full amount and then seek to refinance it in month 10, because you can get a lower rate of interest, that would be a breach. And that's one of the things why the Court of Appeal said that there is no sensible reason that one can understand that. And they said that wasn't what Professor Butler was saying. But the important point that I want to bring out at this stage, of course, I'm not seeking to persuade you that Professor Butler's views, odd they may be, are wrong. That's not the purpose at the moment. What I do say is that what one has got to consider once you consider the case on authority, if you agree with me that there is a representation, you've got to then consider against this background as whether the trustee was put on notice in that it failed to make inquiries that a reasonable person would make. And could I go back to the Satrio case when one's looking at what the right approach is in volume 1 of the authorities at tab...
Sorry, just before we leave Article 16.
Yes.
I'm just looking at paragraph 2. The right to effectuate state internal and foreign borrowings shall belong to the state in the person of a member of a cabinet of ministers responsible for forming and realising state financial budgetary policy, hereinafter Minister of Finances.
Yes. I mean, there's no question the Minister of Finance is, if the state's going to borrow, the person who is to do it is the Minister of Finance.
Yeah.
And just while your Lordship has that, the bit that is relied on about this non-delegation principle is at 9676 at the top of the page. And you see it says there that the Cabinet of Ministers shall determine the conditions for the effectuation of the state borrowing, including the type, currency and interest. Now, the way, again, this is sort of a peculiarity of Ukrainian law. I mean, obviously, I would suggest to an English lawyer reading this, you wouldn't read in that the Minister of Finance wasn't entitled to do this on behalf of the CMU in the light of what's put at the foot of 9675. But that's Professor Butler's position. But that's why I said earlier, well, if that is right, then the CMU full well knows that. Why would anybody expect that the CMU wasn't doing whatever it is that this mandates? And that's what was common ground. You'd have no reason to know they hadn't.
I think, did we not see that the resolution, the Decree 904, did determine the type, currency and interest rate?
It did. But the point that's sought to be made, I mean, it is... I was going to make a rude remark and I'll refrain, but the point... I beg your pardon? Mr. Thankey says I shouldn't hold back. I think he was probably thinking it would be uncharacteristic of me to hold back, but I will on this occasion. But the point that's made is an arid point. I was doing an appeal in Bermuda a couple of weeks ago where I referred to a point as an arid chancery point, but I'm not saying this is that. But what is said is that all the other conditions were delegated, but not the type, currency, and interest rate. Of course, the simple answer to that, if you just look at it as a matter of common sense, these are the particularly important things, and that's why they're set out in that CMU decision. Everything else, you would expect they just look at and say the terms will be set out in the prospectus. Because, of course, as you know, the terms of these notes are largely pro forma, other than issues about term and interest rates. But once you're looking at a question of notice, the board in the Satria case again summarised the authorities very clearly. So that's at tab 3 of volume 1, and it's at MS 303. And this the discussion of paragraph 92 arose because you may remember that there was a question about what Lord Neuberger had said in the final Court of Appeal in Hong Kong. And the critical purpose for present purposes is the first sentence where the board was disagreeing with Lord Neuberger's analysis in that case and said, as Lord Simons explained in Morris and Canson, both the indoor management rule and the doctrine of ostensible authority allow the smooth operation of business by protecting those who are entitled to assume that the person with whom they are dealing has the authority which he claims. But this general principle cannot be invoked if he who would invoke it is put on inquiry. He cannot presume in his favour things are rightly done if the inquiry that he ought to make would tell him they're wrongly done. Then there's a reference to Houghton and rolled steel. And then at 93, the board therefore concludes that P.T. Satria could not rely on the apparent authority of Jones to enter into the HOA if it failed to make the inquiries that a reasonable person would have made in all the circumstances in order to verify he had the authority. And that, in my submission, is the test and the touchstone here, whether or not the trustee, whether Ukraine has a case that the trustee failed to make inquiries that a reasonable person would make. Now, the Court of Appeal, in its approach, it found that the trustee was not on notice of any lack of authority. But the route by which they went down was as follows, that they considered firstly any holding out was simply by reference to Article 16.1. They then said the trustee should be treated as knowing of the contents and effects of the relevant legislation. That's paragraph 121. Therefore, they said, the trustee was to be treated as knowing of an external borrowing limit, which they considered, per Professor Butler, was a net borrowing limit at the end of the year. But they also noted as a fact that it was impossible, that's their word, to see the basis on which it could be said that Lord Debenture should have known that the external borrowing limit was exceeded by the issue of the note. Now, whilst the conclusion on its own terms was correct, the route by which the Court of Appeal got there was based on various errors, some of which I've already highlighted, and in our submission was far too generous to Ukraine and not reflective of the right approach. The result was, and this is what Ukraine are arguing for, it involves ascribing to the trustee full knowledge of Ukraine's tortuous budget laws, treating it as having knowledge and understanding of those laws, contrary to and superior to that held by the relevant Ukrainian persons, that's the Prime Minister, the CMU, the minister and the Ministry of Finance. And one only has to stop there to think something's going wrong when you say an English trustee should be treated as having superior knowledge of Ukrainian law and constitution to all these people. And the error approaches from these two features of the judgment. The first is the incorrect approach to ostensible authority, particularly their view of the CMU. And the second is the point that I've already touched on, the suggestion at 121 that a third party should be taken to know the foreign law, however obscure, without actually asking the right question, whether a reasonable person in the position would have made inquiries that would have led to the knowledge. The relevant part of the Court of Appeal is, on that point, is 121, where there is just an assertion at letter H that the relevant legislation is publicly available and anyone lending to Ukraine is taken to know of its effect. And then clearly a foreign lender is likely to need the services of a Ukrainian lawyer. That's no different from a foreign lender dealing with the UK government. The figures in the budget law are stated in the prospectus, albeit, they're right to note this, not in terms which made clear that they were legal limits. It's something of an understatement. It's not that it didn't make it clear. There's nothing to suggest external borrowing was a limit. But this sentence, as I've said, is just, there's no authority cited for it. It's an assertion. And notwithstanding the eminence of the court, in our submission, it doesn't make any sense. And I would suggest that the obvious and simple approach here, once you're looking at questions of notice, you have to look at the entirety of the circumstances and see, well, was the trustee put on inquiry such that they should have looked into the matter further? And once you approach it in that way, in our submission, none of this arises. And the Court of Appeal went down a false route, treating the trustee as if he was fully aware of all of this Ukrainian law, or Professor Butler's construction of it, when no attention was drawn by Ukraine in any of these documents to the provisions of Annex 2, nor did the trustee have any reason to understand that Annex 2 contained any relevant limits. And indeed, he's expressly told by the CMU and the Minister of Finance that all is in order. So in our submission, that is actually the simple answer to this part of the case. You never get into all this determination of what the borrowing limits actually were and what Professor Butler means. Now,
I mean, what you're saying is actually, after all this, one goes through all this, there's already a very short pointer, which is that sentence of 121 is just wrong.
yes,
And once you take away that sentence, then the question is, what are the reasonable
exactly.
expectations? And you've got all the relevant organs of state telling you you're okay, then you can't do much better than that.
Yeah, exactly. I mean, if you take away that sentence, the whole edifice collapses.
Well, I mean, I don't recall whether Mr. Thankey was supporting that sentence in terms.
Yes, he is. He must be, because once you take away that, and I think his is even more extreme. Because what he says is, it doesn't matter about any knowledge that you actually have. You're treated as knowing the objective truth of what Ukrainian law says.
Well, you've been referred to no authority to that effect.
No, but the extent of this goes on his approach to it. He says the only holding out, Mr. Thankey says, is on the terms of Article 16.1. If Article 16.1, the effect of it, once you go from Article 16.1 per Professor Butler to the budget law to Annex 2, even though it doesn't say there's a limit, if objectively there is a limit, then there is no ostensible authority, no apparent authority, and that's the end. It doesn't matter that any reasonable person would have understood the opposite. I mean, if one stands back from this case, I venture to suggest that any sensible view of this, any court looking at this, if one's looking at what does one think is the sensible result, that it isn't very difficult to see that most commercially minded lawyers would come to the conclusion that the right result is that Ukraine is bound. Our submission is that there is, as your Lordship says, this simple approach, which is look at everything they were saying, and nobody needed to inquire any further. Mr. Justice Blair agreed with that. The instincts of the Court of Appeal were to get to the same route, but Lord Justice Richards, in writing this part of the judgment, seems to have felt constrained by this idea that the trustee must be treated as knowing the entirety of the law of Ukraine and having this superior knowledge to everybody else. So, once you ask the right question, which is, was the trustee in any way put on notice? In our submission, I've shown you the way this is supposed to have arisen, and shown you the key documents. In my submission, the answer to that is obvious, and that this is Mr. Justice Blair was entirely right, that there is no sensible argument. I think I've covered really the documents. And the unreality, and I would suggest this is where any court should be stopping and to ask itself. If you look at the Court of this is what's interesting. The Court of Appeal's judgment was based upon, if you go to paragraph 122, and I'll come back to these paragraphs in a moment to say, well, if you go down that route, they were right. But what they were doing at 122 to 123 was saying, well, Ukraine, through Professor Butler, put forward the borrowing limit, and that essentially what they say is the trustees treated as knowing it, but on the facts, we're not satisfied or we're satisfied he couldn't have known that actually it had been breached. But 124 is interesting because that's where they say that more significant than the internal report, Ukraine issued this statement on the 26th of September 14. It stated that all state debt indicators at the end of 2013 were within the limits. If Ukraine was itself asserting in September 2014 that all external borrowing was within budget limits, it is impossible to see the basis on which it said that Lord Debenture should have known, on or before the 24th of December, that external borrowing limit was exceeded by the issue of the notes. Now, if one just pauses for a moment and just sees what the Court of Appeal is saying, Mr. Thankey says, oh, well, he's wrong, but he says you could crawl through the prospectus and then you could work out that because they've already, at the date of the prospectus in September, 3 billion had been borrowed. Because he says they couldn't have, he says you could work out that they might not have been able to repay any money. You should be able to come to the conclusion that they are exceeding the limits. But the point is, Ukraine was absolutely adamant that it hadn't. And the Court of Appeal's conclusion here that it's impossible to see how the trustee could have come to any contrary view is, I would suggest, a very telling position. And it shows the unreality of Ukraine's position, but it also shows the error in the way in which the Court of Appeal had earlier analysed it. Because where the entire Ukrainian state apparatus couldn't discover for over 2 years this position, it's very difficult to see how a reasonable person in the position of Ukraine, of the trustee, could have done so. And one rhetorically asks, on what legal basis is the trustee being held to a higher level or standard of knowledge than Ukraine itself? So that is my submission as to why the basis on which the Court of Appeal should have correctly reached the conclusion that the trustee was not on notice, and we say therefore was entitled to rely on the representations made. Now, assume for present purposes, contrary to those submissions, that Lord Justice Richard's approach is right, and the trustee is treated as knowing objectively all aspects of Ukrainian law. And that's not just, oh, you should have got a Ukrainian legal opinion, you have to remember. It's that you had to get a Ukrainian legal opinion that was correct. The question then is, if you get to this that way of looking at it, which I say you shouldn't, is the Court of Appeal right in any event that the trustee was not on notice that there was a breach? Now, what the Court of Appeal is saying at 122, it's not, I think, what Mr. Thankey says, the Court of Appeal was construing Ukrainian law. That's not what they were doing. The Court of Appeal was construing Professor Butler's evidence about Ukrainian law. And that's what they were entitled to do. And it was for Ukraine to put forward the evidence. And and you've seen in relation to the debate about the admissibility of this new evidence, that the question actually arose in the course of the hearing as to what Professor Butler was saying. And the two Lord Justices and the Lady Justice were unanimous and asked questions to say that they could not understand Professor Butler's report to be saying that it was concerned with gross borrowing as opposed to net borrowing. And I think at one point in his submissions, Mr. Thankey appeared to say that the Court of Appeal thought you were looking at the totality of external borrowings, whereas actually you can see at paragraph 122, the Court of Appeal is focusing on loans advanced in 2013, and their point is that in the middle of the paragraph, however, nowhere does Professor Butler say that is the effect of the 2013 budget law, namely that if you repay one loan, that it doesn't make any difference, you're only concerned with a gross amount. And just stopping there for a moment, if you have a provision of a provision, let's say of a company or of a state, which says, or say a company says, you mustn't during the course of the year and by year end borrow more than $100 million. If you borrow and repay so that the net position is 100 million at the end of the year, one would have thought naturally that that would be permitted. Now, if you look at it in the context of a country where there's a supposed limit, not stated as such, but a supposed limit of X billion by external borrowing, why, and that's what the Court of Appeal is saying, why does it make any difference if you borrow on day 1, 1 billion, and on day 21, you repay that 1 billion and take out a new loan? Why do you treat that as 2 billion rather than 1 billion? And there's no one can put forward any sensible explanation. Even Professor Butler is unable to do that. What he is saying is just, well, he asserts that that's how the law operates. So in our submission, the Court of Appeal was entitled to come to that conclusion based upon Professor Butler's evidence. And so then they were entitled to come to the conclusion that Ukraine had not demonstrated, if one was going down this route, that it was a reasonable person in the trustee would have known that this was all going to be exceeded. And again, you have to come back to that question. Why would a reasonable person consider when this is going to be exceeded, when he's being told by everybody it's all fine? And the question is not, as Ukraine puts it, what the trustee could or could not have believed. The right question is whether a reasonable person would have been put on inquiry as to breach of the limits. And in our submission, trying to crawl through the prospectus and pick out bits and pieces and say you should have put all of that together and come to the conclusion that actually, contrary to the representations that were made, that this was all unlawful, is, with respect, unreal.
In relation to the remark in paragraph 121 that a foreign lender was likely to need the services of a Ukrainian lawyer, I presume the Court of Appeal knew that there had in fact been reports by two firms of Ukrainian lawyers.
They did, yes. I mean, what they say at 121, it may have been a fault of my advocacy. They say that Mr. Howard took us through the somewhat tortuous process by which the limit for external borrowings would be identified and submitted. A foreign lender could not be expected to discover this limit. Accordingly, that Lord Debenture can't be expected to have been on notice of it. Then they say, well, we accept that it's not straightforward, but we don't accept the legal consequence, because the legal consequence is simply you're deemed to know. And once you come back and say, well, why? And surely the question is, what would a reasonable person understand? Would he be put on inquiry? Once you ask that question, which the Court of Appeal, they don't appear to really have disagreed with the submission I was making. They just don't deal with it really, because they've taken this rather, I suppose, hard line, but I would say wrong approach.
I suppose if you're taken to know of its effect, then even if you do obtain reports from Ukrainian lawyers, but they don't alert you to the problem, that's your tough luck. Your remedy lies against them, I suppose.
The argument, what this amounts to, and you have to put this against all the documents I showed you, the argument is that you note holder, you trustee and the note holders, and it doesn't matter whether it's Russia or anybody else, it's you've taken the risk when you deal with somebody like Ukraine that whatever opinion, whatever we say to you through all of our organs, whatever eminent law firms may say to you, doesn't matter, because what is Ukrainian law is an objective truth which will be, in this case, determined or established by Professor Butler's evidence. And if that is right, you're just stuck. So you can go to 20 law firms, all of whom say it's all fine. That's just the risk you've taken. Well, that's the argument. Is that, and that's part of what the court ultimately has to say, is that really the way these transactions work? Now, when I opened my submissions, I said that these points are important for the operation of the bond markets and the London market. In my submission, the approach here, and particularly the approach that the Court of Appeal is taking when saying if you have a bond issued by one of the 200-odd countries in the world, you are deemed, if you deal with that country, to know anything within its constitution, its laws. What about the position where you've got, like in this country, an unwritten constitution, and we don't even need to go down the a secret law point. So it really is quite far-reaching for these type of transactions. But as my Lord Carnwood said, if I'm right that that is just the simple error, then you avoid these difficulties.
Well, and presumably you say that that this approach departs from the established approach of asking whether the representation on which the ostensible authority is based was one on which the representee could reasonably rely.
Yes, and that's you need to come back to what is the right test in English law. Now, and once one recognises that, and that's why if you come back to what the CMU said as the very simplest, there is a clear and unequivocal representation. In our submission, the question is, it's very difficult to see why you wouldn't be entitled to rely on that.
Focused so far very much on what the CMU did. You also, in your written case, refer to what the Parliament did. Is that part of the picture that you're developing?
The Parliament comes in two ways, Maud. The Parliament's conduct prior to issuing the notes, the Parliament passed a law, the Amendment Law, which, again, one of the oddities of this case is they passed an amendment law which was specifically designed to increase the budget. And what Ukraine now says is that even that didn't work. But I rely on that as part of the context as to why the trustee wasn't to be put on any inquiry, when Parliament itself thought this was all appropriate and was saying so. I don't rely on, at that stage, on Parliament making a specific holding out. Because the reason I don't is the holding out, it doesn't add anything to the CMU, essentially, because the argument against me on the CMU is going to be exactly the same as the argument on Parliament, which is the argument that, as I apprehend it, that is made, is that the CMU, it's a different argument to the one that the Court of Appeal made. So the Court of Appeal, in relation to the CMU, had the point about non-delegation. I've explained why that was a bad point. I think Mr. Thankey would say is, and I think Professor Butler says, the CMU couldn't make this representation because it's in excess of what they can do, because they can't themselves, nor can Parliament, change the budget law. But the answer to that is that the CMU could make a representation that what the minister was doing was proper. I mean, if one just goes back to, that in my submission is the simple point. If you imagine the situation, just this conversation, the trustee, let's say you don't have the decree, he's about to execute these notes, which the Minister of Finance says he has authority to do, and he's acting in accordance with Ukrainian law. So the trustee thinks, well, I've only got the minister's say-so. I think what I'll do is I'll go and see the Prime Minister and the CMU. So he goes into their office and says, look, CMU, can you tell me, firstly, does the minister have authority? And secondly, is this, what he's doing, in accordance with Ukrainian law? The question is, is that within their usual authority to say yes to that? Now, my submission, self-evidently it is, because they're the highest organ in the land. By virtue of being in that position, they may not be higher than the Parliament, but they're the highest executive, I think, agency is the way it's put.
Insofar as if against you that there were, Annex 2 had limits and the Ukrainian legislature altered those limits. It's paragraph 138 of your written case.
Yes.
Altered those limits in advance of the issuance of the notes, then insofar as the CMU was making representations, and insofar as one might see Parliament as the principle as it controlled what the law said, then Parliament, on one view, was acting in a way which was consistent with the CMU's behaviour.
I mean, they were certainly aware of what was going on.
Yes.
I mean, they're part of, that's why I said, you've either got people expressly communicating to us, when I say us, to the trustee, or you've got people publicly, as it were, standing by, allowing this to happen. And when you look at it on the latter way, I mean, as at 138, we've set out that the Parliament and the chairman of the Budget Committee were fully aware of all of this and saying, it's fine.
There is a provision in the law on the CMU that the CMU is under the control and accountable to the Supreme Rada of Ukraine.
Yes.
It's on MS 9679.
Yes, but the issue, this comes back in a way to the discussion we were having earlier, is what I think Professor Butler is trying to say when he deals with this. It's not, this is what I think the argument would be, that the powers of the CMU are set out in the law on the CMU. Those powers ultimately are all subject to Ukrainian law and the constitution. So therefore it said if the budget law says there is a limit on external borrowing, then the CMU, firstly, they don't have the power or authority to increase the limit. That may be true, but that doesn't answer the point that we're making, which is whether they have authority and ostensible authority to tell somebody else that that is all in accordance with Ukrainian law. And in our submission, that is a distinction, and it is a distinction with a difference, that they are authorised, or at least have usual and apparent authority to do that.
But if you were to see the Parliament as the principal in this context,
Yes.
as the representative, the relevant organ of the Ukrainian state, then this legislation was designed to authorise the CMU
Yes.
and the Minister of Finance to,
Absolutely, it was.
to get into it.
And what Professor Butler says is, it's flawed because it wasn't quite enough.
It may be flawed, but at the end of the day, is the Parliament not authorising the CMU to make the representation, as it were?
Well, I would suggest they are.
Yes.
And if you have to look to, I would say you don't need to do that.
You say you don't need to.
But if you do, Parliament is also authorising it. And you then, Professor Butler would say, but Parliament can't do that because they haven't validly increased the debt limit sufficiently, therefore they can't do this. So you always, what you get driven back to is that there's an objective truth and that you can't go beyond that. That's really the issue you have to grapple with. In my submission, that isn't an answer to the case. And that, if it's right, what it means is, and I think Mr. Thankey said this at one point, there is no possibility of ostensible authority because you're either actually authorised or you're not. Now, in our submission, that is contrary really to the whole English law approach to ostensible authority.
Thank you.
Now, the argument which only arises if you approach things in the way that Mr. Thankey in the Court of Appeal did, as to whether or not the debt limit is gross or not. In our submission, I mean, there are two things you have to consider there if one gets to that stage. One is, what does Professor Butler's report mean? And I think you have my submission, that's fairly clear. And the second is whether one admits new material. And one has to bear in mind that the so-called gross argument wasn't raised before Mr. Justice Blair, and it only arose in the course of the argument in the Court of Appeal. And the Court of Appeal made clear their views, and Ukraine took a deliberate decision in the course of that hearing not to produce further evidence, relied on submissions. And they then, when the judgment came out, purported to produce a further report. Now, in our submission, that was all manifestly improper, and that's why it got short shrift from the Court of Appeal. But I don't think I need to develop that any further. You have our written submissions. Before we move off this point, so we've been looking at Article 16.1, and I've explained, you have my submissions on that. There's a separate freestanding point which Ukraine makes, which is by reference to what they say are the supposedly onerous terms of the notes. So they argue that any authority, as I understand it, they say any authority that you were put on inquiry by reference to the unusual and onerous terms, and so therefore it's not open to the trustee to say that the minister in fact had authority. So what they rely on for this purpose are three things. There's what's called a no set-off clause, the GDP ratio, which as its name suggests is that your GDP has got to be kept at a certain ratio, and the cross-default clause. And the cross-default clause, again, as its name suggests, is that a default in relation to some other transaction would constitute a default under this. Now, the question at this stage of the inquiry is, assuming those are unusual or onerous terms, which we don't accept but will assume for present purposes, the question is whether any aspect, those allegedly unusual aspects, put the trustee on notice, or should have put him on notice, of the supposed lack of authority. And that's the critical point. You've got to say that these terms were such that they should have led you to realize that the minister and the CMU were exceeding authority. Once you realize that's the point, it is a completely hopeless argument. Assume, where does this sort of argument normally arise? You have an agent asks the debtor to make payments to him rather than to the company or his principal, and that is what usually puts the third party on notice that the agent is acting in excess of his authority because he's not acting in the company's interest. A useful case, actually, I would like to just show you is a decision of Mr. Justice Lightman, because it also goes back to the earlier submissions I was making. It's a case called Hopkins and Dallas, which is in Authorities, Volume 10. And it's at tab 83. And
Page?
Page 3843, my lord. And the issue was a Mr. Towie signed certain letters of undertaking on behalf of the Dallas group in consideration for certain goods to be provided. You can see that at paragraph 2. And the judgment on page 3846. I won't read it all out, the detail doesn't matter. But at paragraph 3, the judge in the second sentence said these were extraordinary dealings. And the conclusion, if we go forward to paragraph 91, page 3872, he starts to consider authority. And it's quite a helpful judgment in seeing the interrelationship between actual and ostensible authority. And you can see at 88 on page 3873, he makes the point that the grant of actual authority won't normally include authority to act for the agent's benefit. And therefore, without agreement, the scope of actual authority won't include this. And then at 90, he says that, in his judgment, this Mr. Towie didn't have actual authority to sign these letters for two independent reasons. And the first, he says, is that it wasn't within the usual scope of the office that he held. And then at 91, the second is that he entered into the 1995 letters not for the benefit of the principals, but for his own benefit or this third party. So that's why he didn't have actual authority. But then at 92, he considers ostensible authority, which he explains looks at the relationship between the third party and the principal and can lead to an outcome where a company is bound even though it hasn't actually authorised. And then he refers to Freeman and Lockyer. And then at 93, you see in the second sentence, he says, as regards the first condition, it's well established an agent cannot by his own acts confer upon himself ostensible authority, but ostensible authority can arise through a course of dealing, and the principal acquiescence in the course of dealing and honouring transactions. But then at 94, or no, at the end, sorry, still in 93, if you then go to letter G, the only question is whether TTB were honest and had a reasonable expectation to this effect, that's that he had authority. And then at 94, where an agent is acting within the usual authority of an person in his position, the third party will normally not be expected to inquire as to the details unless the transaction is abnormal or there are other circumstances giving rise to suspicion. If there are suspicious circumstances, then the third party should make inquiries. Now, the point of referring to this is no good saying there was an onerous term of these notes. You've got to say the onerous term of these notes was such, or the unusual nature, was that it should have raised a suspicion as to whether or not the Minister of Finance had authority. And the same point was, we don't need to turn it up, was made in the Satria case. And so the simple point is, there is no suggestion at all that the no set-off clause, the GDP ratio clause and the gross default clause somehow indicated that the Minister of Finance was acting in excess of his authority. Still less do they indicate that there was a breach of the budget law or indeed had anything to do with that. They don't show that the minister was acting for personal and nefarious interests, which is what these sort of situations are all about. And what's more, the absolutely fatal point is, in any event, the CMU, by its decree, appeared, as it would appear to a reasonable person, to have endorsed the terms. So, my Lord, that point does not assist Ukraine. Now, the final point, which I think I can take extremely shortly, is the challenge on reliance. And it's slightly unclear as to exactly what it is that Ukraine is now seeking to say. Before Mr. Justice Blair, Ukraine did argue that the evidence didn't support reliance, and it lost. Mr. Justice Blair rejected that. Ukraine did not appeal that point to the Court of Appeal, and that's why it doesn't feature in the Court of Appeal's judgment. Now, we say that's actually the beginning and end of the point, but the way in which Mr. Thankey seeks to put it is to say, take an unrealistic point. He now says, well, as I understand it, he accepts that the trustee did rely on, firstly, he doesn't dispute the trustee did believe that Ukraine had appointed and was holding out the minister as having authority. He doesn't challenge that the evidence shows that, and that it did believe, because that's what was held by Mr. Justice Blair, that it did rely on the holding out. What I think he says is, the Court of Appeal say you can't have any holding out other than by reference to Article 16.1, and your evidence doesn't address Article 16.1, therefore you can't have a reliance case. Now, even if you go down that analysis, it's a totally false point. The Court of Appeal is attributing to the trustee knowledge of Article 16.1 because it says that's what you're deemed to know. But the question is not, did the trustee understand something from Article 16.1? The question is, was there a holding out by Ukraine through the course of conduct that the minister had authority? And the fact that the Court of Appeal says, well, any holding out has got to be subjected to Article 16.1, it doesn't make any difference to what it is that the position of the trustee. So in our submission, the position on reliance was decided by Mr. Justice Blair, not appealed, and the new way of putting it by reference to Article 16.1 does not work. But what an important point also to understand about all of this, if we just go back to the Court of Appeal's judgment, it is also of interest as to how this arose. And if you go to paragraph 95 of the judgment, Mr. Thankey read to you paragraphs, I think, 92, 3 and 4, and 96. What he didn't read to you is 95, which is where the Court of Appeal is dealing with this 16.1. And that said, these issues were raised by the court in the course of submissions. Mr. Howard reaffirmed Lord Debenture's case was based solely on the usual or ostensible authority. Mr. Thankey, on behalf of Ukraine, while of course challenging many elements of Lord Debenture's case, did not espouse a case that the issue of authority was to be determined by reference to the terms of Article 16. Now that's relevant for two reasons. One is because it actually shows that Mr. Thankey, as an eminent commercial lawyer, understood that this approach of confining the holding out to Article 16 is not right. But secondly, the point having been raised in the Court of Appeal, Mr. Thankey didn't seek to say to the Court of Appeal, well, that's the way you're putting it, I'll adopt that, and actually I've also then would like leave on that basis to raise a point on reliance by reference to this way of putting it. I mean, essentially, Ukraine obviously took the view that way of analysing it by the Court of Appeal was not one that appeared to be correct. Or whether that was their view or not, they certainly didn't seek before the Court of Appeal to raise some alternative reliance case. So, my lords, that concludes, not my entire submissions, but it concludes where we get to on authority in terms of entering into the transaction. And so I say this plainly was an authorised transaction of Ukraine. Now, the trustee relied on the holding out. That then leads me, I have two further points that I need to address. One is ratification, if I were wrong on authority, and the final point is the submissions on countermeasures. So turning to ratification, now this issue only arises if the court considers that there is an arguable case that the Minister of Finance did not have ostensible authority to enter into the transaction agreements in the first place. Now, we say that Ukraine's conduct subsequent to the issue of the notes was that it consistently and publicly affirmed the notes were valid and binding obligations. Now, the Court of Appeal, Mr. Justice Blair essentially said that the ratification issue wasn't suitable for summary judgment. And the Court of Appeal agreed because they said it raised factual issues that required further exploration. Now, that conclusion, with respect, was wrong. The correct approach on ratification shows that it is a straightforward point, and that's for three reasons. And they're legal tests, because once you properly understand, or two of them are legal tests, and the third relates to the attempt to use duress in this area. The first is, as a matter of law, all that is required to ratify is that there is an act of the principal that objectively conveys approval or adoption of the transaction, and that the principal can be said to have known of the existence of the transaction and its terms. Now, if we're right on that, there is overwhelming evidence to show ratification. And we say Ukraine is wrong to suggest, as a matter of English law, that knowledge of the absence of authority of the agent is required. But even if that was required, Ukraine had constructive knowledge of that fact in any event. So that's our legal route. Secondly, we say Ukraine is wrong when it suggests the agent performing the ratifying act needs to have authority, actual authority, to retrospectively approve the unauthorized acts. That's wrong as a matter of English law. So we say, against the factual background, there are just these legal questions about what is required as a matter of English law. The third string to Ukraine's bow is it only performed the ratifying acts as a result of duress. We say the duress point fails for the same reason as duress that we discussed earlier, but is in any event, for reasons I'll explain, it would be fanciful and therefore does not give rise to a triable issue of fact. So turning to the first point, the existence of ratifying conduct. Firstly, it's common ground. The question of whether the transaction agreements were ratified is a question of English law. Now, ratification will occur. Perhaps we should look at Bowstead, which is in volume 3 of the authorities at tab 22 at MS 1337. It's Article 17 of Bowstead. So ratification can be express or by conduct. 2, an express ratification is a manifestation by one on whose behalf an unauthorized act has been done, and he treats the act as authorized and becomes a party to the transaction in question. It doesn't need to be communicated. Ratification can be implied, whatever the conduct of the person in whose name or on whose behalf the act or transaction is done or entered into, such as to amount to clear evidence that he adopts or recognises it, and it can be implied from mere acquiescence or inactivity. The adoption of part of a transaction operates as ratification of the whole. Now, the sort of conduct that generally amounts to ratification will be suing on a transaction, or receipt and retention of retention of monies, or use or disposal of goods received under a transaction. And as Balstead points out at 2-075, it'd be surprising if you could keep somebody else's property or money without having ratified. So we see in the commentary, just as a grant of authority may be express or implied, so may ratification. Thus, suing on a transaction or basing a defence on it will, subject to any rules as to ratifications which came too late, often amount to an implied ratification. So also, receipt or retention of money with knowledge of circumstances of a contract under which it was paid will normally constitute ratification, as will use or disposal of goods, unless the supposed principal didn't assent to the transaction, hadn't had no alternative. I don't think we need the rest of it. At 277, they deal with implied ratification, explaining that express ratification will be comparatively rare, and a ratification will more often be implied from words or conduct. Such words or conduct must be unequivocal. They must not be such as they could be accounted for by other interpretations, such as he's simply resuming possession of his own property. Such reasoning is necessary to protect the principal against too easily being held to be liable as having ratified. So all that unequivocal means, though, is there must be clear evidence that you are adopting or recognising the transaction. And Mrs. Justice Gloucester, as she then was in the Seb Trigg Holding case, said as much. That's in this bundle of authorities back at tab 18, page 1241 in the bundle, at paragraph 97 sub 3 on page 1241, which is reciting what you get from Balstead. So what is it that we've set out a lot of things in our written case capable of that amounted to ratification, but there are three, as it were, overpowering things. One is the very simple point that Ukraine received and accepted into the state treasury $3 billion. Received it and kept it, no doubt consumed it. That's not in dispute. The receipt of money under a disputed transaction will normally constitute ratification. We've seen Balstead 275 on that, and cites some fairly ancient cases which support that. I mean, one from 1840, Hunter and Parker, Brewer and Gregory, and more recent one in Simpol and Chi. I don't think we need to look at any of them. They are in the bundles. The second point is Ukraine paid the interest, as I explained to you, on 3 separate occasions. Again, it's not in dispute. And that payment of interest was done, and this goes back to my Lord Hodges' point, with the approval of the Verkhovna Rada, the Parliament, in a separate budget law which was passed on each occasion. That is explained in Mr. Danieluk's evidence. He's the current Minister of Finance at paragraph 41. He's the former, I beg your pardon. And that's in Appendix Part 2, Volume 1, MS 9133. I think when it said he was the former, he wasn't the Minister of Finance at the time of the, just for your note, one of the things you should note about Mr. Debenture, although he wasn't the Minister of Finance, he had a capacity, I can't remember offhand what it was, where he attended the CMU in December 2013. And so we actually do have an individual who's given evidence. Is that it? It's paragraph 11. His evidence is in Appendix Part 2, Volume 1, and paragraph 11, which is at MS 9124. He attended the CMU in his capacity as head of the Coordination Centre for the Implementation of Economic Reforms. I see the time, my lord.
Yes, well, if that's a convenient moment, we'll adjourn and sit again at 2 o'clock.